morning.
Good morning. Could I just check whether you had the transcripts?
Yes, we did. Well, I did anyway.
And there are hard copies. Do you want hard copies?
No, we've got hard copies.
Okay.
Thank you very much.
Oh, I haven't got.
My hard copy
Yeah.
arrived, so please do hand those up. Thank you. But I think we have no transcript this morning. That may be something to do with the traffic. I imagine.
Oh well.
We'll just
Half a hearing.
we'll just battle on. Thank you.
Talking of battling on, I hope this isn't going to be a problem, but my voice actually stopped working altogether last night, particularly when I was hit the cold air. So it seems to be much better this morning, but I hope that doesn't happen again. But you may be relieved if I'm not able to say anything more. But I'll struggle on as best I can. So before turning to Section 75A, my Lady Justice Falk, you asked me yesterday whether HMRC would argue that the proviso to Case 3 to Section 54 applied, even if they had assessed B64 to SDLT and determined that group relief wasn't available. And I said yesterday that followed from the logic of my argument. And I said I'd check with HMRC, and I'm instructed that they would follow that approach, given that you can consider that's how the legislation operates. So, Section 75A, the arguments relating to Section 75A are complex, and it's perhaps a shame that neither the tribunals below needed to grapple with them. To date, as my learned friend explained yesterday, the battleground for the application of 75A has been 75A1C. Before I deal with my learned friend's points on that, can I flag a couple of points which I hope will assist the court? Perhaps we could turn up 75A1C, please, which is in the authorities bundle at page 76. So 75A subsection 1 has three conditions, and they're effectively threshold conditions for the application of the section. And subsection C, 1C, requires that the sum of the amounts of SDLT payable in respect of the scheme transactions is less than the amount that would be payable on a notional land transaction affecting the acquisition of V's chargeable interest by P on its disposal by V. So as I say, this is one of the conditions for the application of 75A. You either get through the gateway or you don't. In their skeleton, the appellant says that the amounts of SDLT payable in respect of the scheme transactions is SDLT on 30 million. And this is presumably because they accept that there's SDLT of approximately SDLT on 30 million chargeable on the appellant. Now, this isn't a point, therefore, that's advanced by the appellant, but and I submit they're correct not to do so, but you may recall that the Court of Appeal in the Project Blue case, in that case, two of the Court of Appeal judges, Lord Justice Patton and Lord Justice Lewison, expressed a view on what was meant by tax payable in respect of the scheme transactions in section 75A1C. And effectively, I can hand up a copy of the report if you would like. They said it meant effectively SDLT due in the sense of there being a liability to SDLT. So they said what it didn't mean is SDLT that had been assessed, as it were. So you have to look at it as sort of theoretical question, really. Was there an SDLT liability arising from that transaction? Now, as you will recall, the Court of Appeal decision in Project Blue was set aside in the Supreme Court. So our position would be that neither of these dicta is binding.
Sorry, was it dicta anyway?
No,
What?
it did form part of their decision in the Court of Appeal, but I think I'm right in saying. But their decision on that, because it all turned on whether the intermediate transaction with a company called MAR,
Yes.
whether it was exempt or not.
Yes.
And the Supreme Court took a different view on that. So in my submission, what the Court of Appeal said isn't binding, but I did want to make you aware of those dicta, so that so you're fully aware of all the relevant authorities.
Sorry, and it's you'll have to help with what that might mean if those dicta were right. I mean, those dicta weren't as such disapproved in the Supreme
No, they weren't.
or dicta or whatever they were, statements,
Yes.
weren't actually disapproved.
No, they weren't. But
If they were right, what would that mean in practice here?
I would say that they were at most persuasive.
No, if they were right,
If they were right.
what would the
sorry.
consequence be?
Yes.
Just trying to understand.
Well, then, if they were right, one would have to analyse what the STLT analysis was on the transaction on the grant of the lease from SGSL to B64.
And I'm guessing that the appellants would say it's STLT on 30 million on that, but
They may do, yeah. And this is the problem, all the arguments are kind of interlinked, because obviously on one view it might be SDLT on the market value of the lease, depending
that's
on where
why
you
I
get
said
on.
the appellants would say.
Yes, well,
And you might
they may
say
change their
some
mind,
other amount.
but in any event, I hope, and this I think will go to the written submissions, that there's a pragmatic answer to this, because on the actual figures, certainly as HMRC interprets subsection 5 of section 75A. Remember, section 75A5 is a provision that primarily tells you what the consideration is on the notional transaction. So if you compare, even as it were, the highest amount one might get to on the actual transactions with what HMRC's argument will be in their written submissions on the notional charge or consideration on the notional transactions, by possibly only a very small amount, if you take the market value of the lease on the in the real transactions. Nevertheless, 75A 1C is satisfied, and so that might deal with the point. And as I said at the beginning, it's just a threshold condition. So if you satisfy it, you satisfy it, and then you go on to look at the other provisions of 75A to C to work out what the charge, if any, would be.
Okay, will you at some point this morning be giving us an outline of what you're going to say?
On 75A 5.
Yes.
I can do. I wasn't planning to, but I'm very happy to.
Well, I just think it might help certainly me at least try and understand what you've just said,
Yes.
as well as at least setting the scene for the submissions and the appellant's response to those submissions, which, as indicated, we're going to want quite shortly.
Yes. I mean, I could try and do that now if it would assist.
Well, could you just summarise, in effect, what you've just said in relation to 75A1C? I think what you're saying is that on the way that the revenue approach it, C is satisfied because the amount that is payable on the scheme transactions is less than the amount that would be payable on your notional land transaction, because you wouldn't take the 30, you'd take the market value.
Well,
I just want to be really simple.
if we took the market value, then
don't follow down my rabbit hole. Tell me I'm wrong and that's not what you meant, and tell me what you did mean. Otherwise, we will disappear into a warren.
Yeah. First point, HMRC are not happy with the dicta of the Court of Appeal in Project Blue. I just want to make that clear for the record.
Well-
I wouldn't want to be taken to agreeing with it, but let's assume that that you were to apply that dicta.
Yes.
What that would mean is that on HMRC's arguments, you would have to impute market value on the grant of the lease from SGSL to B64, and you would have to take either 30 or 200, depending where you get to on the other issues, on the assignment of the lease from B64 to the appellant.
Sorry, we're in a world here necessarily where you've lost on the appeal.
Yeah.
So why, on what basis do you say, well, it has to be market value on the grant of the lease?
Because, well, depends what you mean by lost on the appeal. The second issue that I'm going to address this morning on 75A is this issue about whether you can, whether the carve out to the market value rule in section 54 applies. And so if HMRC were successful on that, then there would be a market value charge on the grant of the lease.
Sorry, on the grant of the lease, there's
Yeah.
been no prior transaction on which group relief was claimed.
Yeah.
On what basis would the market value rule apply?
Well, we wouldn't. HMRC are relying on in the actual transactions of the ground of appeal.
I'm looking at the grant of the lease. On what
Grant of the lease,
basis would
there
the
wouldn't
market
be any
value
way in which the carve out from the market value provision could apply.
Why?
So,
It's been, I think it's been said against you that the case 3 exception would apply.
yes. So it said again. It said that there would be a distribution in the real world from B64 to the appellant.
Now I'm talking about the lease grant here.
Yeah. And we would say that the argument then is on SGSL. SGSL is a bare trustee.
Okay.
So you're into the second argument on section 75A then. So they're not aligned. You'd have to look, we'd have to revisit
Okay.
that point.
So you say.
And that's what, yeah, sorry.
Okay. So you say this gets into the substance of the argument on 75A.
Yeah.
Where you say you would apply market value to the grant of the lease.
Yeah.
And then going back to 75A 1C, that would mean that well, what does that mean?
That would mean you'd have to compare assuming that we're applying the statements of the Court of Appeal, compare what SDLT should have been payable on the actual transactions with what section 75A5 tells you is the chargeable consideration for the notional transaction. And what I'm saying is that if you do that, albeit by a small amount, you still get a higher SDLT figure on the notional transactions, assuming you're with us on how 75A5 applies.
And from my understanding, what's the small amount? Where does that come out?
It basically comes through from the fact that there was a £1,000 capital contribution that was paid that tips it over the threshold.
And will your submissions explain how you think subsection 5 applies?
Well, that's what I was
Yeah.
thinking we were doing by way of written submissions. I can I can outline it now if you would like.
Please, would you at least outline where you're going now, so that we can fit all these pieces together
Of course.
as we go along?
Yes. So, section 75A5 is on page 76 of the authorities bundle. So I'll just ask you to read that.
Okay.
So we say that there are alternative provisions there looking at what was given or received under the scheme transactions, and the provisions allow, in the bit in brackets, for aggregation in certain circumstances. So HMRCs submit that the chargeable consideration for the notional transaction pursuant to 75A5 in this case is 230 million, and this is because this is the aggregate amount received by V or persons connected with V. So we're within V.
Can you explain exactly how you get to that number?
Yeah. So on the transactions in the real world, I haven't got this. I can provide the actual specific figures, but just
No,
in
rough
round
figures are fine.
terms. Grant of a lease from SGSL to B64 for 30 million.
Mm-hmm.
Sale of shares by the Topco Berkeley Group PLC to the appellant for approximately 170 million, and assignment of lease from B64 to the appellant for 30 million.
So the revenue take the position that even though the aggregate clearly works out to be more than the value, that is the result.
Well,
Because I mean, on that interpretation, you can do any amount of double counting under subsection 5.
well, I'm going to show you
no
another. I'm going to show you another provision in a minute, which would mitigate that. But you say it's more than the amount, but it's important to bear in mind there were two land transactions here. So it's not just. I know we focused on the assignment from B64 to the appellant, but there was another land transaction, the grant of the lease. So in my submission, it's not that surprising that one might get to consideration for something over 230. I should say, I do apologise, and I want to reiterate what we said in our letter sent to the court on Monday. I took over this case at the Court of Appeal level. I confess that as I worked it up for this hearing, the 75A arguments became, in my mind, much more complicated. So I do apologise to the court for this. It does seem like, up until now, the parties have just sort of proceeded on a particular basis that there were these two discrete issues, and I'm sorry about that.
Tell me, Mr. Henderson, does it mean that you need to amend your respondent's notice? I only asked that. I haven't
Well,
looked at it.
on this point, on the subsection 5 point,
Yes.
potentially, although my understanding was that the parties agreed this pragmatic way of dealing with it. I should say, my lady, I am apologising to you because I need to apologise to you, but this is a point that both parties, it was incumbent on them to bring to your attention. 75A5 is clearly a relevant provision in terms of working out the chargeable consideration for the notional transaction. So it's just a gap.
If I can interrupt, it struck me that there may be a need, just for formal purposes, to amend the respondent's notice so that the record shows what the issues are.
Yes, in that case, I would apply
I don't think
to
my
this.
lady was suggesting you're not entitled to run point, or that you have to argue for permission to amend, although we haven't heard formally from the other side. But it seems that it is a good idea.
Yes.
Just in case these things go further, or people look at the record later to make clear what the issues are.
Perhaps we should ask Ms Shaw what her position is in relation to the 75A 5 point. As I understood from the letter on behalf of the revenue, it was that it had been agreed that this issue should be dealt with in written submissions. Is that right?
That is right, although we did reserve our right to, as part of those submissions, to object to the point being raised.
Yes.
And this is the first time that it has been suggested that the 75A 5 point results in 230 million of SDLT being payable. So up until now, the suggestion was that it produced a result that tax on 200 million was payable. So this is...
I mean, I think there may be a formal answer to that, which is you haven't sort of... you only assess to...
Yes,
I mean, the pragmatic point actually
I-
is that the revenue only assessed 200 million. So I don't see how they'd ever collect.
No, and we didn't appeal the FTT decision.
So I don't think you've got a practical problem on that point. I'm sure you're
Okay,
not,
so it's not being
well,
suggested
I mean,
that now...
unless it's positively being... I mean, the tribunal, the first-tier tribunal could, in theory, have increased the assessment, but it was never pursued.
No.
The chances of, unless the revenue, well, I don't know what the revenue are going to say, but you're not trying to
No,
increase
I'm
the
not.
assessment.
I made that. I thought we'd made that clear in the letter.
Okay, fine.
Okay,
So
well,
you're pointing out what the technical result might be.
I'm
that
sort of
fair?
trying to finish the puzzle that no one
Yeah.
has finished yet, and I think it's incumbent on both parties to do that, and the court would want us to do that.
Okay.
I'm not seeking at this stage to suddenly say, well, is SDLT on an extra 30 or anything like that, but I wouldn't suggest that that bars me from following through the analysis, even if at the end of the day that means that we haven't.
But we're clear that
Let's
we're
be
clear.
clear.
So
Let's
that-
be clear.
But
That
the,
is
the
helpful.
assessment does not, whatever the result, the assessment does not end up being increased. I think that's.
And so you were following through on your logic and the numbers, but that was all.
Yes.
Okay. And on that basis, Ms Shaw.
That's very helpful to that clarification, and thank you. So on that basis, we have agreed that we will set out our case. At the moment, we don't understand the arguments, and so we would like to understand what exactly is being said about the interpretation of the provisions and in particular the aggregation of those the various amounts that have just been outlined.
Well, Mr. Henderson can correct me if I'm wrong, but what I understand the revenue to be saying is that the scheme transactions include each of the lease grant, the share sale, and the transfer of the lease, and that what you have to do under subsection 5 is add the actual consideration for all those together, including the share transaction.
Yes, and the capital contribution. Yeah.
Yeah.
Yes.
Yeah. Sorry.
Well, I don't know about the capital contribution, but
Well, that was the small amount.
That was the £1,000.
unless that's
Yes.
just reflected in this share sale price, I don't
Yes.
know.
And perhaps you consider the respondent's notice point, but let's not be held up by that now.
Would you like us to make an application to that effect?
I think to the extent that it's necessary to tidy up where we are, then that should be done.
Yes, we will do that. Thank you very much.
Let's go back to the jigsaw.
Yes. So the jigsaw, I wanted to make you aware of what the Court of Appeal said in Project Blue, and just to be clear about that, that is a point that is potentially unhelpful to my clients. But I thought it was important that you were aware of that.
I think you said you had copies of the report
Yes.
available. I think it would be helpful.
Would it be helpful if I just showed you the relevant passages?
Yes.
Yes?
So on page 383 of the report, halfway down paragraph 35, you see where it says Mr. Gammy says that.
Yes.
If I could just ask you to read to the end of that paragraph, please. This is the judgment of Lord Justice Patton. Mr. Gammy was, unlike in this case, was representing HMRC.
Payable on the completion of the transaction.
And then right at the end of the judgment, Lord Justice Lewison on page 388, the penultimate paragraph, about 7 lines up, the second is that. Payable does not, etc.
Sorry, which paragraph?
So it's the very
right,
penultimate
yeah,
paragraph of
yeah.
the judgment, and then about 7 lines up from the bottom of that paragraph, which begins the second, is that.
Ah.
So second half of the paragraph is paragraph 52.
Yes, but on page 388.
Yes. So HMRC's position is it doesn't agree with these comments.
Yeah. But we accept, at least in this court, it may be difficult for us to argue otherwise, but I'm instructed that they would want to reserve the right, if necessary, to argue the point, perhaps in the Supreme Court. If necessary, in this case, as I say, our primary submission doesn't arise because of the numbers.
Okay, so we are back in section 75A.
Yeah. Do you want me to deal with the actual arguments in advance now?
Yes, please.
Actually, just before I do that, just to test your patience a little bit more, can I just show you one other provision? We can do this very, very quickly. Which I don't think you were showing yesterday, but just to help. 75C10, which is on page 78 of the authorities bundle. So in my submission, this is a potentially quite important provision in the context of 75A, because it effectively gives the taxpayer credit for SDLT actually paid on the disregarded land transactions. And so it will often take a lot of the heat out of a 75A argument. So let's just say, for the sake of argument, that B64 had paid SDLT on the market value of the grant of the lease, and the appellant had paid SDLT on either 30 or 200, then this provision would come into play. But as we know, in this case, B64 did not pay any SDLT. So, returning to the actual arguments, the appellant argues that the notional transaction would attract group relief, and as a result, it can be said that some of the amounts of the SDLT payable, whatever that amount may be, is less than the amount that would be payable on the notional transaction, because their argument is it's zero on the notional transaction because of the availability of group relief. And we accept, as we made clear in the letter, that if the appellant's argument on that is correct, then the section 75A argument falls away in the appellant's favour. However, as you know, HMRC's submission is that the notional transaction does not qualify for group relief. Could we go back, please, to section 75C, subsection 2, which is on page 77 of the authorities bundle, the notional transaction under section 75A attracts any relief under this part which it would attract if it were an actual transaction, subject to the terms and restrictions of the relief. So we say those closing words, subject to the terms and restrictions of the relief, are very important in this case. And we say that group relief wouldn't be available in this case because the notional transaction would be treated as taking place in the context of the arrangements relating to the transfer of the lease, those arrangements being the ones that engaged section 75A in the first place. And the FTT has decided that one of the purposes of those arrangements was the avoidance of liability to corporation tax. So we say group relief would be denied by virtue of paragraph 4, subparagraph 4A of Schedule 7. Section 75A deems there to be a notional land transaction, but section 75A4 only disregards scheme transactions which are land transactions. It doesn't disregard any scheme transactions which are not land transactions. In this case, the capital contribution and the transfer of the shares are not disregarded, therefore. And those scheme transactions, it's no longer disputed, had a main purpose of the avoidance of tax. And it's in that context, the context of those scheme transactions, that paragraph 2, subparagraph 4A needs to be considered. Now, as I understood the appellant's argument from their skeleton, their contention was that the notional transaction envisaged by section 75A was an entirely hypothetical one, so that the circumstances of the actual transaction couldn't be taken into account. I think orally my learned friend has put it slightly differently, and the way I understood his submissions, he sought to argue that... Sorry?
Submission.
No, it's...
Mr. Brodsky's.
Yeah. So I'm very capable of making that sort of mistake.
No, I'm so sorry. Mr. Brodsky's submissions.
Mr. Brodsky's. He put it in two ways. He said factually and legally.
Yes.
And I want to take those in first with the legal submissions and then the factual ones.
Yes.
And I think you know what my submissions are on this already. Section 75A is a deeming provision of sorts, clearly, but I submit that the appellant's approach takes the deeming effect of Section 75A too far. And in that context, can I just take you to two relatively brief passages in the authorities on deeming? First of all, the Fowler case, which is tab 17, page 312 of the authorities.
Probably still the most recent authority on extent of deeming, isn't it? Or leading authority.
I hope so. Yeah. And I'm also going to take you to an SCRT case that refers to it. So, Lord Briggs's speech. This case was about whether a diver's income was taxable in South Africa or in the UK, and it turned on whether certain articles of the UK-South African double tax treaty were to be applied in the real world or in the fictional deemed world of the UK's income tax legislation. If we could go to the passage on page 321 of the bundle, please. And ask you just to read the short section under the heading deeming provisions, please. very much. And then if we could then turn to the Brown and HMRC case, which is on page 383 of the authorities bundle. Brown concerned an SDLT avoidance scheme, and if you're happy to do so, perhaps I could just ask you to cast your eye over the head note to get the background. So, my lord, are you?
Yes.
There were essentially two issues in Brown. One was what was the chargeable consideration under the Section 45 notional contract, and then there was a procedural point on whether HMRC were required to make a separate determination, in that case invoking Section 75A. And in that context, could I take you to page 394 of the bundle, please? So that starts, under the scope of HMRC determination, Mr. Birkbeck accepted it if the claim to relief under Section 45 succeeded. Section 75A is in principle applicable to the series of steps. But then he said HMRC weren't allowed to rely on 75A. And could I just ask you then to read paragraph 66 through to 69, please?
So this is obiter, isn't it?
Yes.
If understood correctly.
Yes, I think that's right. So here we have Lord Justice Lewison saying in that case you can't ignore the real world acquisition of the property, and I submit that a similar approach has to be taken in the present case in relation to whether one can ignore the tax avoidance main purpose in the context of the Section 75A notional transaction. And I say that one has to do that can be demonstrated in various ways, but my overarching submission is that the notional transaction wasn't intended to exist entirely in the abstract, ignoring aspects of the actual transaction. can we then go to Schedule 7, paragraph 2.4a, please, which is on page 131. We've seen this obviously a number of times. Paragraph 2, subparagraph 4a is clearly one of the provisions of Schedule 7 that needs to be considered when determining whether SDLT group relief is available. And we say in deciding whether para 2.4a applies, the only purposes that can be taken into account are those relating to the actual transactions. Because, subject to my learned friend's factual point, which I'll come on to, we say there are no other purposes that can be taken into account. And we submit that surely the correct approach cannot be, and I'm not sure my learned friend suggests it's to effectively ignore paragraph 4.2.4a. Now, an important point turns on paragraph 2.4a little a, because that says that group relief is not available if the transactions are not effective for bona fide commercial reasons. So that must require an analysis of the reasons for the actual transactions. Otherwise, a taxpayer could never satisfy that condition. In other words, there's a positive requirement to show that the transaction is effective for bona fide commercial reasons. And how else could that be demonstrated other than by reference to the purpose of the actual transactions? So,
I mean, it's framed in double negative terms, but you say, because presumably you say it's up to the taxpayer to establish that group relief is available. Therefore, they must, in practice, positively establish that there were bona fide commercial reasons.
And so I say it's impossible to ignore little a, and it's impossible to ignore little b. And even on the appellant's approach, as I understand it, all that's disregarded are the scheme transactions, which are land transactions for SDLT purposes. That's what they say at paragraph 91 of their skeleton. But there's nothing that demands that the corporation tax avoidance, in this case, is simply ignored when you apply paragraph 2.4a. And, of course, it's an important point that group relief, the appellants are seeking to rely on a relief. They're not just saying, let's tax this particular transaction to SDLT. They're saying, no, the notional transaction benefits from group relief, and it would only be available if the real-world relationship between the vendor and the purchaser companies is taken into account. And likewise, the applications of Section 53 and Section 54 require an analysis of the real-world circumstances. But why stop taking into account the real-world circumstances when you get to paragraph 2, subparagraph 4a? We say that you don't. And it's no answer to that in my submission to say that the notional transaction, had it been undertaken, wouldn't have given rise to corporation tax avoidance and so on, because, as I've sought to submit, that is not how the provisions work. As to my learned friend's reliance on Section 75C3, if you recall from yesterday, submission was made that, well, when Parliament wants to, it specifies particular, it's on page 77 of the bundle, provisions, in that case dealing with paragraphs 7 and 8 of Schedule 7. But the short point on that is the mere fact that the Parliament's chosen to clarify a specific point in relation to reconstruction relief and acquisition relief. And it looks like what Parliament was grappling with there was to ensure that it was okay if only one of the scheme transactions if any of the scheme transactions is entered into for the purposes of connection. So they were providing a specific rule for reconstruction relief and acquisition relief. In my submission, that doesn't take away at all from the submission I've just made. And obviously, we haven't even got paragraph 7 and 8 of Schedule 7 in the bundle. We'd have to have a detailed look at how that all fitted together to deal with that point properly. But in my submission, it just doesn't arise. And my learned friend also took you to a paragraph in Project Blue, Lord Hodge, paragraph 42. I may not, perhaps we should just go to it, in fairness. So that's tab 16. On page 289 of the bundle, if you recall, I think it was yeah, look at that whole paragraph.
Sorry, tab 16.
Tab 16 on page 289.
It was the motivation point we were taking to.
Yes, and then I think in particular my learned friend took you over the page to the second part of that paragraph. This is
Yes, yes.
But the short point I make on that is that Lord Hodge was clearly not in that paragraph grappling with the issue that is before you as to the extent of the deeming and availability of the relief in relation to a notional transaction. He was making a general point. So I say, in short, ignoring the tax avoidance purpose takes the deeming too far and outside the realm of intended scope and purpose of the provision. And once tax avoidance is taken into account, group relief is not available. Now, as I say, my learned friend also raised a factual argument. He referred in particular to, if you recall, to two paragraphs in the FTT decision, paragraph 41 and 42, where the FTT referred to the appellant's group's original plans as regard the tower. Do you recall those? Or yeah. And those paragraphs were repeated at paragraph 17 of the Upper Tribunal decision. And the submission was made that somehow that should be the purpose of the notional transaction. But I submit that's simply the wrong approach. You can't sensibly take some finding about what the group didn't end up doing to inform the purposes of the notional transaction. I submit that unless purposes are to be ignored altogether, and you have my submissions on that, then it must be what actually happened and the transactions that are actually entered into that must be the focus of the consideration. I would add, just as an aside, and I don't want to add to your wrath, but this, as I understand it, this is a new point that the appellants are making. It wasn't a point that was advanced in terms of how you approach the notional transaction in the FTT. I wasn't involved, but one might speculate that if it was a point that was being advanced, the evidence might have been handled slightly differently. But
Was 75A was argued at both levels below.
Yes,
In fact, it is briefly addressed by the FTT.
yeah.
Yeah.
They just say it doesn't apply, don't they? Yeah. But the point I'm making is that if it was said, well, one of the reasons why 75A doesn't apply is that you take the original thinking of the company, then cross-examination might have been very different. You can see on the actual issues that were decided, what was relevant to the group relief claim was what the purposes were of the actual transaction. But anyway, I just make that point in passing. It's not
very easy to see what the cross-examination would have been about a hypothetical.
Well, but that rather makes my point, I think.
Well, it doesn't. It rather undermines your point. You're saying that things would have gone differently in a way that could have favoured you if this argument had been raised earlier. But it's hard for me to see, anyway, how you could have cross-examined about what the purposes would have been of a transaction which was identical to one that they had in mind in reality before they got advice from
but as I understand it, the point that's being made against me now is that my learned friend is relying on those two brief findings about what their original thinking was to say, well, that must give you the answer to what the purpose of the notional transaction was. And so if that were their, as it were, evidential case, then cross-examination could have been undertaken as to, well, was that really your original plan?
That would have been a natural line of cross-examination if you were trying to establish a tax avoidance motive anyway. That was my thought.
Well, maybe, but maybe one would have focused on more on what the thinking was once PwC had come into the picture. They were the ones who came up with the avoidance scheme.
As I understand it, though, your main point is that those findings relate not to what actually happened.
Yeah, that's my main point.
And you say that we have to judge by reference to what actually happened, even though if the notional transfer was implemented, it wouldn't have produced any chance of corporation tax avoidance. Well, at least not that we know of.
Not that we know. No, I mean, my main submission is how the provisions operate. You just can't avoid looking at the purposes of the actual transaction.
Yeah, you also rely, make sure I've understood this, you also rely on the fact that the share sale isn't to be ignored.
Yes.
And so far as I've managed to understand the corporation tax planning, that share sale was part of that planning.
Yes. As was the capital contribution.
Well, that may have been to cure a company law problem.
Maybe still part of the scheme to avoid corporation tax. So that is my main point. But I didn't want to not make the procedural point. Unless I can assist any more on that argument, I was just going to turn briefly to the very final point about the carve out.
Thank you.
So the second argument involves the appellant seeking to restrict the chargeable consideration on the notional transaction to 30 million. So whereas the first one, it knocks it out altogether, the 75A, this is to restrict it to 30. We've seen that 75C6 imports section 53 into section 75A to C. So prima facie, if a connected person transfers an asset to a connected company, then the consideration for the transaction shall be not less than market value. The appellant argues that section 53 could not apply because the notional transfer of the lease from SGSL to the appellant would fall within the case 3 exception in section 54(4 as a transaction which is or is part of a distribution of the assets of SGSL. And you've seen our response to that, which is that SGSL was not the beneficial owner of the tower, it merely held it as bear trustee for St George, and accordingly the grant of the lease by SGSL could not be or part of a distribution of the assets of SGSL as required by section 54(4)A. So that's HMRC's simple response. In passing, I would also submit that clearly 75A5 could be relevant in this context, and we'll cover that in our written submissions. But just focusing on the argument that's been put, the appellant contends that the effect of paragraph 3 sub 4 of schedule 16, perhaps we should go to that again, it's on page 141 of the authorities bundle. So 3.4, where a lease is granted by a person as bear trustee is to be treated for the purpose of this part as it applies in relation to the grant of the lease as vendor of the whole of the interest disposed of. So yes, that provision is treating SGSL as the vendor. And can I then take you to a couple of passages in Sargent and Sims, which explain this provision. That's behind tab 31 on page 590, please. So if we start on page 590, and under the heading Bare Trust, the second paragraph under that heading, the exception is the grant of a lease. The trustee is treated as the purchaser of the whole of the interest acquired, where it takes the lease as tenant, or the vendor of the whole of the interest disposed of when it grants the lease as landlord. It's worth noting here that this exception has the potential to disrupt the SDLT analysis that one would expect to apply in certain circumstances. See below. The concept of bare trust is defined in paragraph 1 of Schedule 16. And then on the next page, I'm not going to go through all these examples, but we can see that the authors of Sargent and Sims set out various scenarios where this deeming can lead to problems. The exception for lease grants in paragraph 3.3 has the potential to produce undesired results, where the identity of the vendor or purchaser is important to the availability of a relief. And then they go on to deal with some of the issues. And then finally, on page 592, the penultimate paragraph on that page, perhaps I'll just let you read that, which seeks to discern what the original purpose of this provision was, some sort of anti-avoidance. So it does appear that this paragraph 3.4 has caused some anomalies, but it must nevertheless be applied in its common ground that it applies in this case. But my simple submission is that it can't simply go so far as to treat SGSL as making a distribution of its assets. That's what section 54.4 requires. SGSL was a bare trustee and had no, as I understand it, no assets of its own. So this is, in my submission, another example of the appellant seeking to take a deeming too far. Yesterday, my lady, you expressed some doubts about whether it was even right to treat the notional transaction of the grant of the lease as a distribution at all.
Well, presumably as regards, I can't remember the corporate structure, but as regards the beneficial owner of the lease, was B64 must have been owned by it.
Yeah.
So if you looked at the beneficial owner, which I know we're not supposed to do, because paragraph 3 tells us otherwise, it would be a very strange thing to say that you make a distribution to your own subsidiary.
Well, would it not, though, be the distribution, just looking at the structure of the transaction, if you were to, as it were, ignore
that's not the situation we're in, but
yeah.
If I recall correctly, B64 was a subsidiary of St George?
No, it was a subsidiary of Berkeley Group PLC, the very top co. So it was a
yeah, but who sold the shares in B64?
Berkeley Group PLC.
Ah, so it wasn't, okay. I thought it was a subsidiary of beneficial owner, but it wasn't. So it was it was another sideways transaction.
Yes. Which obviously in theory could be a distribution, assuming they were distributable.
Sorry, I interrupted you.
I mean, the point that occurred to me overnight, but I'm not going to rely on this because I don't need to, but just to sort of mention it, is it's not at all clear why the chargeable consideration for the notional transaction means that the notional transaction is a distribution. I think it all goes back to what is the chargeable consideration for the notional transaction. 75A5 again.
This is somewhat circular.
Yeah, rather wish I hadn't made that point now, but
That is completely circular, isn't it? Because
Yeah.
you're trying to work out.
yeah. But you can't assume. I think what the appellants are doing is they're assuming it's a sale as an undervalue for 30 million. But why? And that takes us to our written submissions, I think. But as I say, for present purposes, you have my point there as to
Yes.
the application.
It
3-4.
does, if you're right, it does create an anomaly in the sense that if the legal title and beneficial title had not been separated, the appellants could have relied on these points, couldn't they?
Well,
Potentially.
it would depend, I think, still on what one said the chargeable consideration was for the notional transaction. Because
But
if
that's
it gives,
precisely what you're trying to decide under section 53.
well, but then you also have to look at 75A5 as well for that purpose. So if you get to let's just say hypothetically you got to a market value consideration on that, then you haven't got a sale of an asset at an undervalue.
But to get to that, you've got to answer the question under section 53.
Well, the way I look at it is that there are basically two provisions, relevant provisions in this case, that tell you what the chargeable consideration is on the notional transaction. And I think probably logically they go in this order. One is to look at 75A5, and that gives you a test. And we're going to make submissions on that. Then, so that will give you a number. But then we're told by 75C6 that you're allowed to apply section 53 to work out the chargeable consideration or the notional consideration. So just, let's for the sake of argument, just say that one concluded, I don't know, that the 75A5 number was 100. It can't be 100 on any view, but let's assume it's 100. You would then look at 75A6 and section 53 and say, well, can I deem the notional transaction to be at market value based on section 53? And that would then give you a higher figure. But if the figure that you obtain under section 75A5 is already higher than the market value of the relevant asset, then you don't need to trouble yourself with that, because all that section 53 says is that the consideration will be not less than market value.
Okay, so you actually say that if you were right about the 230 odd,
Yeah,
you would not take that down to market value
I do, yeah.
under sub 6.
Or indeed, if you thought it was just 200, you wouldn't bother. You're just going to get back to the same
You
figure.
rely on the 53(1)(a), which says the chargeable consideration should be taken to be not less than.
Yeah.
So it can be more than.
Yeah. So unless I can be of any further assistance, those are my submissions.
Thank you. Mr. Brodsky.
Just a couple of small points in reply. If we could look at Brown, which my learned friend took you to at page 394 of the authorities bundle. It's tab 21. The rather ambitious argument for the taxpayer in that case was that the notional Section 75A transaction should have been the subject of a separate determination by the revenue. So that's the extent to which the court in that case is saying, well, you don't take the deeming provision so far that you need to make a separate determination. It's quite different to our case. And what they say at what the court says at paragraph 69, in that first sentence, in this case, I consider that the purpose of the notional transaction and its only purpose is to calculate the amount of SDLT due. So we are within that. And they're saying, well, that doesn't extend to there having to be a separate administrative provision. So we do fall within that scope. And at paragraph 68 above it, 4 lines down, the sentence starting in short, they say, in short, it is necessary to identify, if possible, the purposes for which and the persons between whom the statutory fiction is to be resorted to, and then apply the deeming provision that far, but not where it would produce effects clearly outside of those purposes. In the case of SDLT, the deeming provision does not mean the real-world event should be ignored for all purposes. So, in effect, it's a purposive test, and looking, we would say in accordance with my submissions yesterday, at the rationality of how far you take that deeming provision. And it's in effect the revenue's case that the notional transaction is stitched together with the share sale, and there's nothing in paragraph 68 or 69 to suggest that is what you should do. And they've relied essentially on a literal and not a purposive approach. And actually, the reason that you disregard the land transactions in section 75A is because otherwise you'd have charge on those land transactions and on the notional transaction. And that fits with what the court says in Brown at 69, that the purpose of the notional transaction and its only purpose is to calculate the amount of SDLT due. So that's why they say disregard the land transactions. It doesn't mean that you are calculating the SDLT on the notional transaction as if it were stitched together with the non-disregarded transactions. That's not what the legislation says, and there's nothing in Brown to suggest that is what you do. That's really my only point in reply, except this, which is more of a question, really. But it's our written submissions. It would be helpful to know, I wasn't quite sure from my learned friend, if the revenue's position is that the Court of Appeal decision in Project Blue is binding on this court in respect of that point that he took the court to, or not. If he's making a point that it's not binding for some reason of precedent, then we'll have to address that in written submissions. Or if it's or if the revenue is simply saying they're reserving their position.
Maybe I can clarify. I understood Mr. Henderson to say that because the Court of Appeal's decision was set aside by the Supreme Court, he didn't think it was binding on us and wanted to say that the revenue disagreed with those points. Whether it's technically binding or not, it's obviously highly persuasive for us. I don't think that can be disputed.
That's very helpful, thank you.
So if I've misunderstood that can obviously be clarified.
You haven't.
Thank you. Thank you very much, and thank you, Mr. Brodsky.
Thank you.
Yes, yes. In relation to that, we would be grateful if the HMRC further submissions in relation to this extra point were served and filed by 4 p.m. on Friday, this Friday, which I think is the 28th of November, but I mean this Friday. And that the response to that on behalf of the appellant is also filed and served by 4 p.m. on Tuesday of next week, which I think is the 2nd of December.
That's absolutely fine. Could I just clarify, just so that there's exactly what you want us to make submissions on? Is it just section 75A5?
As that is the new point, and that is how I understood it. Yes.
Yes, I'm not quite sure whether you think that the point that's just been adverted to is potentially relevant to that, so you need to cover it off.
I'm very happy to set down in our submissions why we say it's not binding, and then obviously the appellants can say things.
I think I think that would be helpful to cover that briefly. I'm hoping these submissions can be relatively brief.
But presumably it would help the court, and don't worry, it's not going to span to pages and pages. But if we set out what our analysis is, and then we say how that then plays out in terms of the SDLT analysis, rather than just a simple, we think 75A equals this.
Yes, I think that would be very helpful. I think you've also got the sense that brief is better than a book.
And it may be helpful just to confirm what you've said, which is there's going to no attempt to actually increase, ask this court to increase the assessment.
Thank you.
Thank you very much. Thank you to everybody for their very helpful submissions, and thank you to those behind and those who have not spoken. I'm sure you've all worked extremely hard on this. Very interesting and very difficult issue. As you all know, well, first of all, we reserve our judgments. As you know, in this court, we circulate drafts of our judgments for you to assist us with typographical errors, but not to re-argue any points. We also hope that you will be able to agree consequential orders once you've seen our drafts, and if you are unable to do that, that you put in writing, but in very short form, what your dispute is in relation to the potential order. I should also mention that, of course, the drafts are subject to an embargo, which we take extremely seriously. Thank you very much indeed.